It is July 10th of 2026, and this is the Court Gallery. Coming up, a father's principled stand against child support meets the hard reality of contempt of court. And Judge Hesselink is here to explain the facts of life to the man. Then, we head to Judge Stevens' courtroom, where probationer's story about being a hard-working Lyft driver completely unravels under questioning, revealing a pattern of terrible decisions that might just send her to prison. And we'll finish with Judge Middleton, who presides over the conclusion to an epic legal battle between two razor-sharp attorneys arguing the finer points of mobile home eviction law. Stick around, because the only thing higher than the tension is the cost of being wrong. And it all starts right now.
Matter before the court is Melissa Klein and Dustin Price. That's file 11-14071-DS. Mr. Price is with us, I hear, or I see. Take yourself off mute, Mr. Price. Mr. Brzezinski, is this your matter?
Yes, Judge.
Could you update me, please?
Yes. On June 10th, the referee recommended the defendant appear before Your Honor today for a hearing to address the issue of contempt. This recommendation was due to the fact that the referee found the defendant has the ability to pay all or some of the amount due, and payments have not been made as ordered, and that the defendant informed the referee that he would not be making payments in the future. Currently, the obligation is $1,329.37, and the balance owed is $10,391.48. And there have been no payments made since the defendant has become the payer of support.
And when was that?
The order entered February 20th of 2026.
Mr. Price, what do you say?
I mean, I don't know what to say, honestly. I don't feel like it's appropriate for me to have to pay this. I feel like I've been slighted by the courts. I feel like Miss Klein is not out for the best interest of my children, and she is only looking for a paycheck, and that is one of the main reasons why I don't have an intention to pay this amount.
So tell me, other than your feelings, tell me why you shouldn't have to pay child support.
So this right here represents the amount of motions that I had to file from 2011 to 2014 to gain custody of my kids. During this time, Ms. Klein was not present in their life. She was using drugs. She missed every single court date due to being in jail for stealing from Walmart or accepting prescriptions from Meyer that were not hers. Every time I was blocked for custody. I have written affidavits in here from people that says she took my children to drug houses and left them in the car. These are the hoops that I had to jump through as a father while paying Miss Klein child support and having them in my care full time when my oldest daughter was 2 and my youngest daughter was 8 months old. From 2014 until November of last year, the kids resided with me full time. The only child support I ever received from Miss Klein during that time or help with the children was ordered by the state because when I first gained custody of them, I was on state assistance. She never paid the full amount, only the amount she had to do in order to not get a bench warrant, which was usually paid by her father. This right here represents from 2019 a letter from her rehab, which states that she is unable to work and requesting that I ask friend of the court to discontinue child support payments so that she would not go to jail, which I did. So come October of this past year, my children were upset with me because they did not like my girlfriend and they expressed that they wanted to live with their mother. And she immediately took that and filed for custody. And after one hearing, Kyle T. Legal said that because she asked and he does not see a reason to not grant her custody, she was provided everything, including the $1,300 a month. Now, to me, that seems a little biased that I had to go through this when she was endangering my children's life and using drugs, and I was paying her child support and she was not in the children's life. She had one hearing and was awarded way more than I ever received from her. Now,
so Mr. Price, hang on. So there's a court order that says that you owe child support, right?
correct.
I get it. You disagree for all those reasons. You disagree with that. So did you appeal that order?
No, because once again, my experience with the court, these are the amount of motions that I've had to file to get custody. She filed one motion. That to me seems like a bias and a waste of my time. And I also consulted a lawyer who told me that it would be a waste of my time to file a motion because
Mr.
my
Price?
children.
Mr.
What's
Price,
that?
do you see what I'm holding? Do you see what I'm holding up?
Yeah.
This is not the only case that has inches of paperwork on it.
I understand that.
There's hundreds, if not thousands, of cases that have inches of paperwork.
I
So the
understand
fact that you have inches of paperwork has no bearing on whether or not the orders should be granted. If you don't like an order, your option is to appeal. That's what that's for. You can say there's a legal reason or there's a factual reason that I disagree with the court order. But if you don't do that, then I, as a judge, have to follow the court orders and enforce the court orders. And if you simply say, I'm not doing what the court orders, that's called contempt of court. And the possibilities for enforcement of that contempt of court is going to jail and paying fines in addition to all of the child support that you owe. So I'm telling you that so that you understand what the consequences of your actions could be. Now, I don't. Go ahead, sir.
The consequences of my actions would be. So a couple of things to know. I did consult an attorney on this, and Mr. Legal did mention that I should file a motion to change custody back because my oldest daughter has lived with me since this arrangement was made, and my youngest daughter has expressed a want to return back to the home or have more time here, which Ms. Klein has blocked due to the overnights rule and to maintain her number of overnights. I consulted a lawyer and I was told that it would be a waste of my time to file a motion because the judgment was likely made based on the kids expressing that they wanted to live with their mother, and any changes to that within 6 months that didn't warrant a significant change would be a waste of my time and would not be honored. So I've attempted to do things the right way. You know,
so now you want to do things the wrong way?
Well, here's another instance where I'm being asked to pay child support for children that are in my home. My oldest daughter has continued to live with me. She didn't live with me for a month. My youngest daughter is in bed sleeping in my house right now, and we share 50-50 custody, 1 week on, 1 week off. That's 182 days apiece. Why am I having to pay her child support when it's equal time?
So have you submitted that information to the friend of the court? Is that a change from when it was ordered?
No,
Your Honor, can I
it's
say
not
something?
a change.
I do have something to say if I could just, I don't mean to
Yes.
interrupt.
Ms. Klein, if you would put your video on, I would know that you're there so I could talk to you. But in a minute, I'll talk to you. So just hang on. Thank you.
Okay.
So,
Okay.
Mr. Price, is the current court order, does that indicate that they're aware that your oldest daughter is living with you?
So I just got a notice of abatement in the mail because a friend of the court took our last show cause hearing into consideration.
So they've appropriately acted on that new information, right?
Correct.
So why are you bringing that up now if you're not paying child support for that child? It's been abated.
Well, it hasn't been abated yet. That's the notice, or the date on that abatement is July 16th. I'm bringing it up because the youngest child who has expressed wanting to be back in the home, and we split custody 182 days right down the middle. why am I not receiving child support for the time that I have her in my home if Miss Klein gets child support for the time that she's in her home?
The child support is not just based on how often the children are in your home. It's also based on income levels.
I
so
make
that it evens
$16
out.
an hour.
Right. So that there's a child support formula that takes into account how many days or how many overnights the child is in each of the two homes and the income levels of both parents. And
So
then it makes a recommendation.
Me making less money than Miss Klein means that I owe her $1,300 a month? I make $16 an hour.
Did you object to the child support order?
I attempted to. I didn't file anything because once again, I was instructed that it would be a waste of my time by the lawyer. I wouldn't have a case.
Then what do you want me to tell you, Mr. Price? You had an opportunity to have all of this information hashed out. An order was entered based on the information that you submitted, and now you don't want to do what the court orders you to do for all of the reasons that you could have brought up before.
I have brought it up before.
Then it's been overturned or overruled, and you've lost. You don't get to say, I don't like it because I lost. You have to have a legal reason why to bring something to change it. And you haven't told me anything to change it yet.
Okay. One of the things that Ms. Klein used in getting custody was how well my youngest daughter is doing in school. I have a copy of her most recent, let me find it here. So she went from being an academic scholar with certificates and 4.0 to her entire time with Ms. Klein having a 2.67 GPA. That denotes a decline in her academic abilities since living with Ms. Klein. Would that be enough to change it?
So have you appealed or have you filed a new motion?
No, I have not filed a new motion.
Then I can't do anything about it.
Okay.
Everybody's entitled to notice. That is, you have to file and say there's a reason to change things. Ms. Klein is entitled to notice of that. The court is entitled to notice of that. Then we have a hearing on that to determine if it changes anything. I don't just make decisions when you bring them up in court. Everybody's entitled to know it ahead of time. All right. So if you believe that there's been a change of circumstances, which is what the lawyers were talking to you about, you have to show that there was a proper cause or a significant change of circumstances since the last court order. If you meet that standard, then we can determine whether or not there is sufficient reason to change things. But today is not about what's going to happen in the future. It's about you're not paying things in the past. You've told the referee, I'm not going to pay. So you're in front of me for me to decide what's going to happen based on your failure to pay. You've been ordered to pay. You didn't appeal that order to pay. So what should I do to you to motivate you to pay? Because if you simply say to the court, you're going to go to jail. And I don't think you need to do that. Tell me I'm wrong.
At this point, I don't know what to say, Your Honor. I will file a motion.
That doesn't stop me from considering whether you go to jail or not for failing to pay in the past.
No, I understand that. I understand the consequences of my actions. And if you need to hold me in contempt and send me to jail, I will accept the punishment.
Why should I do that if you have the ability to pay? You see,
I don't have the ability to pay. I was unemployed for 6 months. I make $16 an hour. I do not have the ability to pay $1,300 a month for children that one spends full time here and another one spends half of their time here.
What do you do for work?
I work in production at LaHaye's Cannabis in Sheboygan.
Why were you off for 6 months?
I was unemployed. I was previously working at PNC Bank for 10 years. That 6 months I spent trying to find another job.
So why were you unemployed?
Conflict of interest with my previous manager at PNC Bank. There was a management switch, and changes in the company led to me no longer being employed there.
So why
I was their top performing salesperson.
Why couldn't you get a job sooner than 6 months?
I have 6 months of resumes that I have submitted and applications, and the only job that I ended up getting hired for was $16 an hour in Sheboygan. Why I couldn't get a job within that 6 months is beyond me. I was unemployed when the support order was put in. I was unemployed from December 2nd to June 1st.
There are literally hundreds of jobs out there. You may not like the jobs, you may not want to work at those jobs, but there are literally hundreds of jobs in northern Michigan without people in those positions. So don't tell me you can't find a job. You may not have found a job that you liked, but you can't tell me that you can't find a job in northern Michigan, especially come spring and summertime.
Yeah, June 1st, I got a job. I interviewed in May. That is springtime. That is when I received employment. I was putting in applications and submitting my resume the entire time.
Mr. Brzezinski, is his monthly amount $1,329?
Yes, it is. That includes $1,142 for current support and then $187.37 for medical reimbursement. And yeah, the notice of abatement for the child that's living with the defendant was mailed on June 25th. And then if there are no objections, the abatement would be effective July 16th. And the notice was sent after the friend of the court office received a written statement from the plaintiff identifying that that child was with the defendant.
And that abatement would be how much?
That would change the current support obligation to $889.37 a month, which includes the $187.37 for the medical reimbursement.
Would that amount include the amount towards arrears?
It does not.
What would be his total after the abatement with the amount included for arrears?
I don't believe we have an ordered on arrears on this case yet. And the abatement wouldn't be effective until 6 days from now, so the balance would be relatively the same if no payments come in.
Ms. Klein, you indicated you wanted something to say. What do you have to say to me now?
Oh, I was just gonna comment on when he said he was paying I was just gonna comment and say that I had wrote a letter to friend of the court asking them to stop payment on Emma because she is no longer living with me. But then you guys ended up clearing that up, and then Allison is not 50-50. Kyle had put in parenting time. She is.
You froze up there for a minute, Ms. Klein.
Sorry, I think I lost you. Can you hear me?
Yes, go ahead and finish your thought.
So Allison is, it's 1 week on, 1 week off during the summer, but when school is in session, it is Thursday to Sunday every other week. But that was all I was gonna say.
All right, thank you. So, Mr. Price, I understand that you are now employed full-time, is that correct?
Yes, sir.
And you have one child living in your home, which you're going to receive an abatement for beginning the 16th of this month.
Yes, sir.
You're making $16 an hour, is that correct?
Yes, sir.
Who else is in your home besides yourself and the one child?
Just myself and the one child.
Any other large payments, rent, loan payments, anything like that that you have?
Mortgage payment, $944.72 a month. A home equity payment in the amount of $295.17 or so a month to pay off expenses of being a single dad and raising the kids myself. I also have car insurance in the amount of $228 a month. I pay both children's cell phone bills. That comes out to, I believe, $173 a month. I also have to, my oldest daughter is starting Michigan State in the fall. I need to pay $4,000 for her meal plan, along with any other incidentals that she needs. And then normal utilities and groceries.
Normal utilities would be a couple $100 a month.
Yeah, I think it's like $100 for Spectrum internets. Our heat is maybe $58 a month. Electric's about $230. Water bill of around $40 a month.
Any other debts or obligations?
I have a host of credit card debt, once again, from raising the kids as a single father that I'm unable to pay right now. So I didn't include those in the calculations.
Mr. Price, as far as I can tell, the last dollar amount that you was put into the calculation for child support has you grossing $43.80 a month. Does that sound right?
Yeah, I was still employed at PNC at the time of our hearing, so I believe that was my income at the time.
What were you making in comparison at PNC to what you're making now?
I believe it was $27 an hour plus commission.
You're now making 16?
Yes, sir. I'm still looking for additional or other work that will pay more. This is just to cover bills in the meantime. I'm still submitting applications. Obviously, $16 an hour isn't enough to support.
All right. And so it would appear to me to be appropriate for you to submit new information to the friend of the court.
Yes, sir.
As to your current income information to see if the information that you've given me today is correct. That would seem to meet the threshold for making a new recommendation as to how much money you would owe going forward, which would relieve some of the high price that you're looking at now. So can you do that within the next 14 days?
I took today off of work for this, so I can go up to front of the court as soon as we end the call. It's just, I live on Sheldon Street. It's just right up the road. I will go in there as soon as we end the call.
All right. So if you would bring with you your current income information, check stubs and dollar amounts or whatever verification of that you have.
It's all on the Gusto app. Would that be acceptable? They do everything payroll all on the phone at my new employer.
Mr. Brzezinski, how would you like to get that information from Mr. Price?
He can either print that off and drop it off, or he can email it to the FOC email, which is foc@otsegocountymi.gov.
I think I might already have that written down somewhere. I don't have a pen on me right now, but I'm sure I can get it from the office when I go up there.
Correct. So let's do that. I'm going to ask the friend of the court to conduct a review based on the change of financial information that you have so that we can have an updated amount towards your child support that meets your current needs.
Yes, sir.
And then if you change again in the future, if you get a second job or if you get a raise or if you change jobs, as soon as you're aware of that new information, bring it to the friend of the court. There are guidelines that they use that are applicable throughout the state of Michigan as to how much of a change warrants a change in child support, how much doesn't warrant. So if it's just a small change, you may not change anything. But if it's a large change, such as going from $27 an hour down to $16 an hour, that would be sufficient to trip the change threshold. So I'm going to ask that you do that. so that you can have an accurate current amount that you owe. In the meantime, I need to have a payment from you of some dollars, and I'm not going to tell you exactly how much it is because I want you to work it out yourself. All right. But so that I don't need to put you in jail. You strike me as a man who is upset because of a principle, and I would hate to have to throw you in jail simply because we have a disagreement over principle. Right.
Yes, sir.
So I'm trying to work with you here, but you need to help me out. Child support is owed. You may disagree with why and how much, but child support is owed. The kids have bills. Between the two of you, you got to come up with these amounts. And the law is the law. I can't change it. Neither can you. You may not like it. I may not like it, but it has to be enforced in a proper process. Okay. So I don't want to send you to jail simply because you're upset with the system. So if you make some payment and continue to make some payment over the next month or two, I will not put you in jail for contempt of court. In the meantime, I want you to submit your information to the friend of the court so that they can calculate a current, accurate amount that is owed. And then if you disagree with that amount that they recommend, you can object to it and we can have a hearing on it. And then I expect once all of that is settled, then you can begin to make your monthly payments in full on a regular basis. Or at least you'll have the opportunity to appeal all of that. Or maybe there will be some change in custody. I don't know. But right now, simply saying I'm not going to do anything is going to force my hand and make me send you to jail. Do you understand all of that?
Yes, sir.
All right. So I'm giving you an opportunity to kind of get things right, make some payments. And I'm not going to tell you exactly what that means, but it means a good faith. This is as much as I can do right now kind of payment. And if you're going to fight me on that, you and I are going to go round and round again towards jail again. But so make it a generous amount if you can. All right, sir?
Yes,
and
sir.
Then let the friend of the court do their calculations under the guidelines and they'll make a recommendation, send it to both sides. You'll be able to look at it, check their math, say, why did you do this or why didn't you do that? And you can have a hearing if you want on that issue. Once all of that is settled, then I expect whatever that new amount is going to be, you're going to make the payments towards that on a regular basis until there is a significant change of circumstances in the future. And then you can submit whatever documentation you want at that time. Mr. Brzezinski, when you do this new calculation, I would like you to address the issue of an ordered on arrears amount so that we have all of that on the table all at the same time so everybody knows exactly how much we're going to do in total in the future.
Okay, Judge, we will do that.
Thank you, Mr. Brzezinski. Mr. Price, do you have any questions for me right now?
I do have one additional question. When I go up to the FOC office, is there a way for me to confirm the amount of arrears that Ms. Klein has and have those adjusted against mine? I do believe, I know as of 2019, she was about $1,700 in arrears in child support.
You can certainly have that information from the friend of the court as to what the arrears are so that you can request that those be, and again, it may require some agreement between Ms. Klein and yourself as to how to deal with you're owed this much and she's owed this much. And what do we do with those kinds of things? And the friend of the court, there is a process for doing all of that. So
Okay.
We can certainly give you the current information. And then as a part of the process, excuse me, Mr. Brzezinski, if you would, again, as part of this new update of information, if you could address that information as well with both parties and see how they want to handle it, and then make it that a part of your recommendation so that they can object or not, depending on how they want to handle those things.
Okay, Judge, yeah, we will reach out to them and see if they have any agreement. I think offsetting the arrears that one owes with the arrears that the other one owes would need to be based on an agreement that the two of them have together.
Right. So, but at least if they could have that information so that they could begin to talk to each other, I think that would be beneficial.
Yes, we will get that to them.
All right. Any other questions that you have, Mr. Price?
No, sir.
Ms. Klein, is there anything else that you have questions about today?
I do. When you had asked him to make a payment, is that going to be a monthly payment that you're
Yes.
asking for?
I'm asking him to make a payment towards his monthly support. Yes.
I was wondering if we could maybe put a dollar amount on it and possibly, because I'm still paying $180 for Allison's emergency surgery that she had to have. Which I think that was calculated into his monthly support. Because I filed a motion for that because I wasn't getting help with that. And I ended up paying after insurance covered everything, I owed $3,500. I had to pay $1,000 up front for her to even get the surgery. And then I have to pay $180 every month. And I didn't know if maybe we could at least get that covered per month.
There is a process for determining extraordinary medical expenses. And you can discuss that with Mr. Brzezinski or the friend of the court's office as to how that process works. So I'm not going to, again, when I'm first told about it today, it's difficult to make an off the top of your head decision without knowing all of the facts, without having the other side say, well, but here's my side of the story. So again, the request is not inappropriate, but I'm not going to make a decision, a snap decision, without having all of the facts and information. So if you have a request to make, Ms. Klein, about extraordinary medical expenses, you need to do that in a motion and give that information to Mr. Price. The two of you can talk and see if you can reach an agreement. If you can't reach an agreement, I can make a decision about that. That is something that the two of you need to discuss. And if you can't reach an agreement, I'll be happy to have that talk with you and decision in the future, but I'm not going to make it today. And the reason is, as I explained, I'm not going to make a snap decision where both sides don't have notice of that information. So I've told him what I want him to do. He knows what he owes right now. I've kind of lessened that burden a little bit based on his reduction in earning capacity. And so I'm going to leave it exactly the way I've left it already. And you can bring that up in the future if you can't reach an agreement with Mr. Price. That's all for today. Thank you both very much.
Thank you, sir.
Kiana Kincaid, what about this one? That's yours?
Yes, sir. What the plan is she wants to.
Hold on. Let me go. We're going to get to that here. So it's just exclusively with you.
She's in the back.
Okay. Do we need her out?
Yes, she's intending to plead basically true to several of them and explain them. I just don't know if the state was going to proceed on all.
Well, they can proceed on whatever
Does
they
this
wish,
yeah.
you know, and they can also agree not to proceed on certain based upon how things work out. Everybody was entitled. I've got 2 notes on her, maybe more. I've got a letter from her, and then Dear Judge Stevens, and then Dear Honorable Stephen, people writing on her behalf. Do y'all want to look at this?
He's given me copies, Judge.
Okay.
Not of that.
I don't know that I have that.
Well, it's U.S.
given-
Postal Service.
I've given him the copies of the ones.
Was
that-
sent me by the
presented.
Postal Service. 23 CR 2013 is called the State of Texas versus Kiana Kincaid. That is you, right? You have to speak out so she can hear out loud. Thank you. You have a soft voice. And you were here with Mr. Turk, your attorney, and the state's attorney. There is a first amended motion to revoke probation that is pending. There was a motion to revoke probation filed in December of last year. And then before we could have a hearing on this, a first amended motion to revoke probation was subsequently filed in March of this year, adding 3 more allegations of wrongdoing. So we have a total of 9. It only takes 1 for revocation, but there are 9 violations here alleged. What are we going to do today? We were set for a hearing on it, and
I might just real quick with
Go ahead.
Ms. Kincaid, we have talked about this and your intent today was to plead true to several of these, just not all of them. You just wanted to give your explanation of what the context was to the judge that he understands what's going around with several of these so that he's fully informed. Is that correct? So that's the intent, Judge, is she was willing to plead true
What?
to 2 through, and I'm gonna check her,
Yeah.
2 through 5. These are the immediate report and arrest, the community service hours, out breaking curfew, didn't do the driving course, and she's in arrears on her payments. And then she was in Harris County, and then on 8, it's the compound nature. I think she was incarcerated for at least one of those months, possibly 2 of those months. And then 7, I think it's a typo on their allegation, but it didn't, there's not a failure to ID in Jefferson County. And then on the first one, I don't think the state can meet their burden on the immediate nature of the endangerment.
I don't know if they can or not.
Right, yeah,
But I see what your argument is. He's saying she's going to plead to certain things that aren't substantive offenses. What does the state say?
I have to abandon count 1.
Hold on. Oh, right. It's abandoned.
I will abandon count 6 about fees.
Well, that wipes out the substantive crimes, right?
Yes, sir.
So we got 2, 3, 4, 5, 8, 9. Is that what she's going to be pleading true to? Or what is the state asking?
I didn't hear what his plea was going to be on 8 and 9. If not, I've got the officer to testify.
If I know 8 it's the compound nature, and I'm not trying to split hairs, Judge, but it's 3 months. My understanding is that at least one of those, she was incarcerated in Jefferson County. February, she was arrested mid-month. So she was incarcerated at some point in February. So January being the possible time when she failed to report. So I just, that
Okay.
compound nature.
He's going to admit to January.
Yes, sir.
It only takes 1 month.
Yes, sir.
Or more.
I want to be clear whenever.
All right. So
She's admitting is true.
Does she admit that she was in Harris County without permission?
I would swear.
We need to swear her in, Judge.
I just need to know what the plea
And then
is.
number
True or
9.
Not true.
9 is that she was in Harris County on or about February 17th, 2026, without permission of the probation officer.
Was working.
Hold on. Yes, do you want to plead true?
Is it just,
And
it's
explain it,
just a
please.
yes or no answer?
You can plead true and explain it, or you can plead not true and then make them prove it. And she will testify to what.
We're just talking about what are you going to plead true to?
You're pleading true to these. They just want to know what you want to do with number 9. So number 9 too is what, Judge.
All right. Raise your right hand. You are Kiana Kincaid. Do you solemnly swear or affirm the statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. You were here with Mr. Turk, your attorney, the state's attorney, and the probation office is here. You've been on probation here with this court. And does the defendant, who is now charged with this first amended motion to revoke probation, filed as of March 24th, 2026, waive formal readings of the motion? Can we proceed in summary?
Yes, Judge.
In summary, this motion, first amended motion to revoke probation, alleges that on July 14th, 2025, wow, about a year ago, in this court, you were sentenced to 10 years in prison. That was suspended. You were placed on regular probation for 10 years for evading arrest or detention with a motor vehicle, a 3rd-degree felony. Is all of that true and correct?
Yes.
Yes. Yes. You hesitated, but is all that true?
I'm aware of the 10 years being suspended. I know.
She understood she was on probation. I think the way you phrased it, Judge, suspended, may have just thrown off, but you understand you were on probation.
I sentenced you to 10 years in prison. Then I said, but that imprisonment is suspended so long as you follow the terms and conditions of probation and you're on probation for 10 years. That's the way I always say it. Okay. So we're true, but it's a conviction. but you didn't have to go to any confinement unless the court, as a condition of probation, ordered you to do so. I can't remember. I generally don't, especially if you're in custody at the time. So let's pick up what we can deal with. Number 2, allegation 2 states you failed to immediately report to the probation your new arrest in violation of condition 9 of your probation order. I don't know what that means. It doesn't explain which arrest it is and the date, but is that true or untrue?
Well, when
Is it true or untrue? Then you have a chance to explain. I just want to know, is it true or untrue? Failed to immediately report your new arrest. I don't know what we're talking about.
It would be the arrest for the matter right above it, Judge.
The number 1.
The November 30th, 2025
Correct.
offense of abandoning or endangering a child. Were you arrested for that?
Yes.
Okay, I think that's what they're talking about.
Yes.
Is that true?
Yes.
Okay, and you didn't report that immediately to the probation officer as you were required, correct? All right, so you're pleading true to that? 3, you failed to provide verification of performing community service hours as required and directed. You may have provided some verification, but were you doing all you could? I don't know. According to this, see, the memo states the defendant has performed to perform. That's just a mistake. Has failed to perform, I'm sure. And you had completed, this was as of December 5th of 2025, and you had been on probation since July of 25. As of last December, you had completed 0 hours of your assigned hours. I don't know if has she completed any at all up to now?
0 hours.
So, oh boy, that ought to be an easy one. Is that true? You failed to failed to provide verification of performing community service hours as required in your probation order. True? That you were at a location other than, and it says his residence, you're a girl, right? Yeah, okay. I'm gonna change that to her. You were at a location other than your residence as approximately 11:51 p.m. on or about November 30th, 2025 in violation of your probation order. Is that true?
Yes.
5, you failed to enter and successfully complete the defensive driving course that you were required to perform and complete. Is that true?
Yes.
And 8, you failed to report to the probation office for the months of January, February, and March of 2026 in violation of your probation order. Is that true? Did you stop reporting? And
No, sir.
you reported in January, February, and March?
I did not report in January. I left her a voicemail and I was rescheduled for February the 17th.
Did you report then?
February the 17th, I was arrested that same day.
And you've been in custody ever since? Oh, what do we do? Are y'all abandoning that?
I will, Judge.
9, you failed to remain in Jefferson County, Texas, and that you were in Harris County, Texas on or about February 17th, 2026 without permission of the probation office, which was a violation of condition 7 of your probation order, which states don't leave Jefferson County without permission. Is that true?
Yes.
All right. So are you pleading true then to allegations 2, 3, 4, 5, 7, and 9 of this first amended motion to revoke probation?
Not 7, Judge. I think you abandoned that one.
That's correct.
I'm sorry, it was abandoned. You know what I did is, let me write abandoned. Once again, you're pleading true to allegations 3, 4, 5, and 9.
This time you missed number 2. 2, 3, 4, 5, and 9 is what I have as pleas.
Okay, my final
I don't answer.
answer and conclusion. You were pleading true to allegations 2, 3, 4, 5, and 9. Everybody happy with me so far now?
We're with you.
I'm always
Pleading
happy
true to
with
those allegations voluntarily, knowingly, intelligently, and because they are true as they are alleged. You understand that a voluntarily and knowingly made plea is true to one or more violations of probation. That is enough to grant a motion to revoke probation. Your probation can be revoked. You can be sentenced to no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today? I find you are pleading true to these violations voluntarily, knowingly, intelligently, because they are true. I need a pad, I guess. We got an agreement?
No, sir.
Oh, there's no, it's,
That's part of the reason we're having a hearing today, Judge.
all right. So there is enough to grant the motion. What do we do? State?
I had hopes that I would have an officer here about the November 30th offense, but I could not make that happen, Judge, which was one of the reasons why we weren't able to reach an agreement. That being said, her admissions here are certainly all administrative in nature. But they center around her failure to adjust properly on probation. When we look at the PSI, her offense was for evading arrest. She wasn't following officers' orders in the time frame. Her history in the post PSI indicates that she'd been given an opportunity at probation before for a misdemeanor offense in Chambers County, as well as a felony offense in Orange. And the one in Orange in 22 ended up with her being revoked and receiving 14 months. It's one of the reasons why she got the straight probation offer here. Just like the last hearing we had, my position is that whenever we give someone an opportunity who is working with a felony conviction history and they don't comply with the rules, I'm going to have the position that they need to go to prison. She should have been on notice with that type of criminal history that it's a zero tolerance rule in this courtroom. My preference obviously would have been to have evidence as to the new criminal law violations, but I don't have that. But I do have her conduct admitting to being out of Harris County. That's permission. That her violating her curfew and just generally not adjusting to following the rules that we all do on a daily basis.
You judge.
Go ahead.
If I can ask just in case some questions. It's kind of, because you wanted to give the explanation of what some of these things were, and you understand that when you start talking, he gets to ask questions afterwards, right? So on the immediately reporting, did you in fact call your probation officer after you arrested? It just wasn't maybe the next day?
Yes, I did give her a call. And she asked me to report on the 11th, and it ended up changing to December the 15th. And I reported with her that day. I did make her aware of the arrest, just not the news of it, because it was an accusation.
And you're going off memory right now. You don't have documents in with you in your jail cell or trial. Everything you're testifying to right now is from your memory. And then on the community service hours, let me ask you this. You were put on probation in July of last year, correct? It has not yet been a year. Actually, your year is next month is the anniversary is next week, I'm sorry, for your year date. Can I say something?
Yes.
And you were incarcerated at least since February of this year. So that's roughly about 5 months.
Yes.
And then prior to that, from let's say July until November timeframe, were you reporting and basically following most of the things that you're supposed to do on probation?
Yes, sir. Would report sometimes 10 minutes early just to be sure that I'm ended on time.
And then you thought you had another year or the rest of that year, if you will, to do the rest of the things you were supposed to do that year to include community service hours, right? And then were you also thinking about taking advantage of the food bank program?
Yes,
And were you precluded from doing that because you were in arrears for, you couldn't do the food bank program because you hadn't paid your fees yet? Is that right? Or do you understand that?
yes, yes, she did make me aware.
Are you intending to do the community service hours?
Yes,
If you had not been in jail, would you have worked at some of them?
yes.
Okay. And then as far as being outside of your house or your breaking curfew, what is your job?
I am an Uber driver.
And what does that mean?
That means I pick up people, clients who are in need of a ride.
Were you working on November 30th, 2025 at roughly 11:50 p.m. that night?
Yes,
Had you been working for a couple of hours prior to that?
yes, I started at 8 a.m.
So you were working that day. You were outside your house for employment purposes.
Yes,
Okay. And then as far as the defensive driving class, you thought you had some time, you're on probation for 10 years, right? You just didn't get a chance to do it, correct? Are you going to do it? Is that something that you could fix pretty easily if you can get out? And then as far as being in Harris County, was that in association with your Uber driver?
yes,
Is that why you were over there? Why did you have a passenger?
yes,
And were you intending to stay in Harris County?
no, sir.
Were you going to come right back after you dropped off your passenger?
Yeah.
What prevented you from coming back
I got stopped by an officer.
and arrested? Okay. And then from that date, that was February 17th. From that date till today, you've been in somebody's jail. Okay. You have two daughters.
Yes, sir.
How old are they now?
Ages 10 and 8.
Do they look at you, or have you been their mother? Have you taken care of them up until the time you were incarcerated? Okay. Do you also take care of somebody else? Who's that?
My grandmother,
Do they all three of those need your assistance?
depend on me.
What are you crying about?
Thinking about the children.
Why aren't you thinking about them before you start making violations of probation or committing the offense of evading arrest or detention when they caught you out at 2 o'clock in the morning that you're placed on probation for?
It wasn't intentional.
Oh, somebody put a gun to your head and forced you? Well, all actions are intentionally unless you're out of your mind. I don't think that was proven.
I really do the best I can to make a way from the election.
It's not what you have to follow the rules. That has to be the best you can, needs to be above the requirements of following the rules. People always say, I'm doing the best I can. I just can't seem to be on curfew, perform community service hours, successfully complete defensive driving, on and on, failing to report. Failing to remain in Jefferson County without permission. And let's don't forget all the circumstances of this offense in the first place. You were driving around with a silver Mercedes at 1:06. It was registered to a white Tesla 4-door. You didn't even have, there was one wrongdoing after another. Then the police, New England police chased that and had to chase you, and you were driving in and out, fleeing through a bank parking lot, several streets, entered townhomes in Port Arthur, then jumped out and then fled from the police. Were you thinking about your children at any time? You were doing this was in their best interest?
That was my place of residence at the time. And
Up until then, you were running from the police. Which part? Which part? Driving a vehicle that had the wrong registration on it?
I just had purchased that car and that's how it came. I haven't made any changes
Purchase it from whom?
from some person who's
Who?
selling from Beaumont.
Who?
I can't remember his name.
Uh-huh.
But I have
That always
records.
happens here. It's instead of what everybody else does is they go to a dealership, a legitimate dealership. No, you're dealing off the street with people you claim you don't know, you know. And your memory is fading. That's what I get all the time. But the fact of the matter is, this was at 1 o'clock in the morning when you had children at home.
My children were with my mom that day.
What are you doing at 1:06 in the morning? Aren't you supposed to be a mother?
Yes, sir.
Okay. They're not. So they're with somebody else at 1:06 in the morning while you're driving, while the police are chasing you with a vehicle that's registered to another type of vehicle. Why did you flee from the police in the first place?
Because he was stalking me everywhere. I
The
went.
police were stalking you?
Yes, sir. I went to the store, he followed me at the store. I went to McDonald's drive-through. He circled around the drive-through. I stopped at my family's home. He circled that area 5 times, turned the bright lights on. I was scared. I didn't know what he wanted or what was happening. I was really scared.
The first sentence of their probable cause affidavit is that I, along with other Nederland police officers, observed a silver Mercedes-Benz passenger car displaying a temporary tag that was issued to a white Tesla. And then everything happened after that. So they weren't stalking you. They're doing their job. They recognized that you were in a falsified vehicle that had falsified tags. And they're supposed to ignore that? No, they were doing their job. So when they put their emergency lights to stop you, then you flee.
To my home. It
You
was
fled. When they put their emergency lights, why didn't you pull over and stop? Like we all are supposed to by law.
in fear.
In fear? Okay. Once again, you're driving a car with temporary tags that's registered to a Tesla, not a Mercedes. They had all the business in the world to properly stop you. Sorry, you're committing a crime. And you compounded it by fleeing and running. And this is at 1 o'clock anyway. Nothing good happens at that time. Generally. Not when you have children. Don't think of them. Nonetheless, here we are. What are we going to do?
Yes.
Go ahead.
All right. So I remember you testifying at a prior time in here with the court. And the question came up about whether or not you were working for Uber or for Lyft. Which one is it?
Yeah.
Okay.
How
And
long were you working with them? About?
Just started, maybe about a month.
before the incident?
Yes, sir.
So and the one I've got a few questions about this, but I wanted to clarify, it's for Lyft, right? So with the employment, did you report that to the probation officer and get permission to work the kind of schedule that you're talking to the judge about?
No, sir. I wanted to be sure that I was okay with the job before I made any commitments of the job.
So on your own, you decided, let me test this out, see if it works, right?
So working my way towards paying.
With full knowledge that you had a curfew requiring that you couldn't be out unless it was for employment purposes, which implies
That goes in that. other-
they've got to know, they've got to approve it. They've got to see your work schedule. They have to know. You're saying, yes, you understand this. So I'm looking at records, ma'am. Do you actually have a valid driver's license?
I have a license.
He asked for a valid license.
I'm not sure.
In fact, you had a charge from May 5th of 2025 for not having it, for driving without having a valid license. That was out of JP Court Precinct 8 here in Jefferson County.
You're not sure? Who's not
Yes or
sure?
no, ma'am?
Who's not sure about that? Everybody's sure
This
about
is
whether
the
they have a
this
driver's
is the
license.
warrant that I'm showing you for the fact that you didn't resolve that. Do you remember this or not?
Yeah.
I'll be
All right, so maybe you have a valid license.
Wait a second. You live at 5531 Grant Avenue?
That is the previous address I lived before, yes.
Second house from Hoggaboom Road. The second house from Hoggaboom Road. It's the second house off of Hoggaboom Road and Grant Avenue.
Yes.
2 blocks to Van Buren, Woodlawn to the, I grew up in that house. What are the odds of that?
Small world. All right, so you may or may not have a valid driver's license. You end
Go
up,
figure.
the court's already gone over with you the problem with the car that you had about the temporary tag and whether or not it matched, right? And they also talked with you about purchasing through people, right? Folks who don't have a valid driver's license have to go to a third party instead of a dealership. Is that why you did that?
I just saw the price for sale, and a decent price that I could afford.
All right, so when you were stopped on November 30th of 2025, you were in an Equinox. Were you not? Are you aware that the documentation showed that it matched up to some Mercedes vehicle instead of the Equinox?
No, I was not.
Okay. And you admit what time frame it was. And this is you working without permission from the Jefferson County. And you had your girls with you in the car, did you not? And they were not properly seatbelted in anywhere in the car. They were in fact where?
In the back. Yes.
You told the officer they were asleep in the trunk at that time, but they were actually, it's not a trunk, it's one of those lift backs where they're laid down in blankets back there.
Yes, that's open space. And they were with me due to the fact that I did not have a babysitter that day. And I had been working all day and I wanted to continue to work to make extra money. So that way I could cover probation and the bills that I had incurred.
Were one of these children that we're talking about, were they one of the children that you got charged with driving while intoxicated with a child under the age of 15? Right. My question for your offense in Orange County, where you were given probation for driving while intoxicated with a child passenger, was it one of your children?
It's gotta be, right?
Yes, sir.
Right. So it's the same one that you've been telling the judge that they need you at home with them. Let's go forward to correct, right? Those are the ones you want to go home to, the same ones that were victims of an offense that you were placed on probation before in Orange County, correct?
My children always with me and take very good care of them. I'm a great mother and they love me. They say that I'm the best mom.
But were they secured properly in the vehicle when you were driving?
Yes.
Which time, Judge?
The one we was talking about?
November 30th of 2025, when you had those children
They
in
were
the
laying in
back
the
of the
back.
vehicle, are
They
you,
weren't secured.
They had a body pillow and a blanket with them, and they were in the back of the SUV due to the fact of me working and having clients to keep them from.
You get into a car wreck, a head-on collision, they go flying out the windshield, right? Then wouldn't that probably happen.
Because they're not seatbelted in, correct?
I mean, that's why you're supposed to secure them in those seats, those proper seats for security.
So we
But
go,
that's a rule.
we go forward in time to February 17th of 2026. You're still operating as a Lyft driver, correct? And it still has not been approved by the probation department, correct? Is that a yes? And you were once again in a vehicle that did not match the the license plate and car information didn't match. The officers told you that, correct?
Yes.
And you actually had a warrant out for your arrest for this particular motion to revoke probation, correct?
Yes.
On this occasion, you were in a Chevy Equinox, but the license plate registration went back to a Mercedes-Benz.
I'm gonna object to this as hearsay.
It's asking a cross-examination to, she can either say yes or no.
Still hearsay. Overrule. Go ahead. She can answer if she knows.
You were in an Equinox, correct? And the license plate information came back to a Mercedes-Benz.
That I did not know.
Are you aware that it didn't match your vehicle?
I wasn't aware until one of the officers told me.
And in fact, when the officers asked you to identify yourself, you didn't give them your proper name, did you?
I was scared.
So you didn't
What was
give
that?
them.
Yes.
Yes, sir.
What name did you give?
My sister's name.
And the officers claimed to find in the vehicle items they claimed could be marijuana. Is that right?
I did not
They didn't tell you that?
know.
They didn't tell you that they found 3 different bags, including items that were in your purse, and that they suspected that it was marijuana?
Whose car was that again?
My car.
Okay.
Specifically, what was found in your purse was a rolled blunt. You admit or deny that?
They did not tell me that was.
You admit or deny that you had a rolled blunt within your purse, ma'am? And you are saying you had no knowledge of 3 different pouches of marijuana found in that vehicle, correct? I don't have any other questions for her, Judge.
Try anything for the.
Just a couple, Judge. The cases in Harris County, are they still pending?
I was informed that that lawyer is getting those dismissed.
Do
Who
know
told
if
you
they-
that?
Do you know if they've been dismissed?
Who told you that? How do you know that?
My lawyer, Patrick, in Houston.
Somebody else told, a lawyer told you that?
My mom spoke with that lawyer.
And then your mom told you?
Yes.
Okay, go ahead.
But your understanding is that they've been dismissed?
From my knowledge, yes.
And were on the night when when your girls were in the back of your SUV, were they in any immediate danger? Nothing was like, there wasn't a gun back there or bombs or anything, nature wasn't imminent.
Yes.
Have you ever failed a drug test whenever you were dealing with the probation office?
No, sir. No. I haven't done any drugs.
And have you been to court or done anything with your Harris County stuff?
No, sir.
So you weren't able to get discovered where you're, they were saying over in Harris County.
No, sir. Received a PR behind being investigated.
Is there anything else that you think that the judge should know or about you? I mean, and I'm going to refer the court to the letters that the grandmother, I think the stepmom and Ms. Kincaid herself wrote to you.
This is hers as well, which.
Anything else that you want to tell the judge?
I truly apologize for what has occurred. It was not intentionally. I'm not a bad person of continuous bad behavior, nor am I threat to society. I want to do the right thing, and I want to be included in your 93% success rate of probation. And I love my children dearly, and I try my best to not put them in harm's way. I just made a mistake, and I'm very sorry. And I don't think that my kids need to suffer.
I'm sorry, I can't hear you.
I don't think that my children need to suffer without me, because they keep asking for me to be with them.
Okay. And but you're stating that you, except for what we've talked about here, you wouldn't put your children in harm's way. Is that correct? As a mother, have you ever put them in harm's way? No? Is that, no, I can't hear you.
No, sir. I do my best to not put them in any type.
You gotta do more than your best. You gotta do it when you're child. I'm a parent. I know what it's like. Problem is, you've been convicted in Orange County of driving while intoxicated with a child under 15 years of age. Isn't that true? You were not only convicted of that, you were placed on probation, and you lost that since your probation was revoked in 24. And then you were sentenced, what, to 14 months in the state jail? You know what that's like. That was happening, and then I placed you on probation after, I guess, you were through, you finished the state jail over there. You came over here, and then we placed you on probation. And then we've got all these violations now. Okay. All right, anything else?
No,
Just real quick, Judge, your daughter's AB honor roll, doing well in school. They're active in like youth activities. Church, that's one of the court to do that.
Anything else?
No, Judge.
Okay, what's everybody asking for? State.
the letters that she receives from families really supportive for her. I agree. She's got good, strong family support. I just don't think she's got a realistic viewpoint of what the kind of decisions that she's making. She doesn't even recognize the kind of harm that she's exposed her children to on more than one occasion. And I think the kids are doing fine without her. And that's a blessing for them. As I stated earlier, I gave her an opportunity to do the right thing. She's failed at it. I'm asking that you revoke her and give her prison time.
How much, what are you talking about? 2 to 10.
She has not received any significant penitentiary time, and we're not dealing with an actual finding of new
No.
offenses here. So I would suggest on the low end of the punishment range, Judge. I'll say 4 years.
Judge, as we discussed earlier with this revocation, she was put on probation. Presumably that was all of the issues and incidents were taken that Mr. Ham has alluded to were taken into account for that probation. That's why she was put on probation in part. The allegations that remain on this particular revocation, she didn't make the right decisions in some areas, but they're all administrative, and she's explained what was going on. She knows now that she should call her probation officer and tell her she's got a new job. She wants to do the community service. She wants to do defensive driving, but she has been incarcerated for short of half of the time of her first year. In fact, I think next Tuesday is her first year. She just hasn't had the opportunity in full to complete those requirements. She is requesting reinstatement on probation. She's willing, if the court looks to increase the conditions, I think she would be amenable to that, but she does want to get reinstated so she can go back, do the right thing, learn from what she has been doing, what not to do, so to speak. But extend that second chance that the court granted her with this case to a time where she can actually demonstrate sufficiently to the court that she is worthy of the probation that you granted her.
All right, anything you want to say? Anything else, man? I think I understand what you want, but anything else you would like to add?
Yes, I'm not a troublemaker, and I feel that
You committed 2 felony offenses now. And I'm not talking about the marijuana probation as a misdemeanor, but you've got two felony convictions. Yeah, you can talk about what you are, but we are judged by the choices we make. You're making bad choices. You can talk about how good you are, but you've got 2 felony convictions now. And you're on a second felony conviction, and you got several violations of probation. It's still, you can't just talk about it. You got to do the right thing.
I can guarantee to walk a straight line with zero tolerance.
You promised you'd do that when I put you on probation. Promised the other probation people you would do that. You signed the same documents. It's the same kind of documents. You know what you're supposed to do, and any violations can result in revocation. And here you are again. You make the same statements before. Well, you got to do it. Don't just make promises that you don't keep. Oh. Anything else? I'm going to find that there is sufficient evidence supporting this motion, first amended motion to revoke probation, to grant it by a preponderance of the evidence or greater, as allegations 2, 3, 4, 5, and 9 are proven true by a preponderance of the evidence or greater. Your probation is hereby revoked. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You will be given credit for all time you have served. It looks like you've got 130 some odd days already. You could have been sentenced to up to 10 years. This is your second felony conviction that we're dealing with. The first one was a state jail felony, but this one, any subsequent felonies, it's going to be, the punishment range will be added a degree level higher for any future felony wrongdoing above a state jail felony. But your mistakes have consequences, and you're back again for similar type of mistakes. Fix that. You've got reasons to be out there taking care of children, but you're not doing it at 1 o'clock in the morning as you get caught committing crimes when your children are somewhere else. You got to show how important they are by your actions. Anything else? That is all. We are in recess.
It's 10:57. Let me go on the record. Mr. Captain is here on behalf of the park. This is a continued Centerville Mobile Home Park versus Roger Wired and Ray Wired. The file number is 261836LT. It's 10:57. The matter is scheduled for 11. The Wires aren't here yet. Neither is anyone from the park. I didn't know if you guys wanted to touch base for a minute in a breakout or just wait to start at 11.
I'm certainly always happy to touch base with my my counterpart, and I know Attorney Landman had this file previously, and I talked to another attorney Swistek and Levine earlier this week, and she said, we've got it with Dan, question mark. So,
Let me, let you guys touch base.
I can speak with her.
All right, more of the world's most boringest live stream. It is 11. The clock just bonged at the courthouse. The defendants are here. Good morning. Sit right here if you would. You need to move your hat. Good morning.
Morning.
The lawyers are here. They're in a breakout room talking. They were here a little early, and Mr. Landman is unavailable. So Attorney Capitan is here, and Meg Bauer is speaking with him right now. Well, you're close enough. You could just walk to court. Did you walk over?
No.
Or you drove over?
Yeah.
It's only 3 blocks.
Yeah, dog didn't want to get in the kennel, so we were running a little bit behind.
Good morning. The attorneys are talking in the breakout room. So we're just contemplating the nature of the universe while we wait. We blocked out the rest of the morning for this case, so we're not in any time crunch.
Good morning, Your Honor.
Good morning. We're kind of in a holding pattern here. The Wyards are here with me in the courtroom. Meg Bauer from Legal Aid and Mr. Capitan from the law firm are talking in a breakout room. So I'll put you in a waiting room. I won't start without you, but when they come back, I'll bring you back, okay?
Thanks.
I didn't think they had that much to talk about, but maybe they do. I'll give them about 3 more minutes till 11:10. I'll bring it back. I'm gonna bring the lawyers back here in about a minute.
Judge, Mr. Capitan is attempting to call his client.
And
All right, I could just put him in a breakout room with her.
yeah, please, Your Honor.
All right, Mr. Senzo, I'm gonna put you in a breakout with Mr. Capitan. And we'll start over again. And then we'll sit here and look off in the distance for a bit.
So sorry, Your
Just hit the button that says join. Meg, the Wyards are here in the courtroom with me. And we'll just wait a little bit while they talk.
I guess I should stop trying to call them then.
All right, do you want to speak to them?
If the honor will indulge it, if Your Honor will indulge it, we're attempting to not
All
have,
right,
you may have to make a decision.
Laura, could you open one of the conference rooms? Mr. and Mrs. Wyard, I'm gonna put you in a space where you can talk privately with Meg from Legal Aid. So, Ross, would you take them out to the conference room, and as soon as I get it set up, I'll put them in there. You got an interesting shirt there, except
You like that?
Wolverine on Saturday, Lion on Sunday. That's okay unless you're green and white.
I was I can't see the shirt, but I was just gonna say my clients have done what I wish most of my clients would do, which is turn their phone off when they go into a courthouse.
Well, they've paid all their escrow. They've been at every court proceeding. You guys can talk while they're talking.
Thank you. My gratitude to Elaine and Laura as well.
All right, thank you. All right, that leaves just me here staring at the wall. So I'll sit here and wait. Thank you all for watching this. Not as boring as it gets. Anyway, I'm hopeful that they'll come to a solution, so it may be time well spent to let each party talk to their client. If you just logged in, today's first line of rock and roll poetry and a shared moment of humanity. Just when I say, boy, we can't miss, you are golden, then you do this. You say, this guy is so cool, snapping his fingers like a fool. one more expensive kiss off. Who do you think I am?
Your Honor, thanks for waiting.
You're fine. In the meantime, I put Meg and the Wyards in a separate breakout room, so they're touching base also.
Okay, thank you.
I've got the whole morning blocked out, the last hour. Anything you guys do to get closer to resolution is probably time well spent. So me and 5,000 viewers are sitting here watching an empty courtroom, but we'll see how long
Is
it
there,
takes.
is there really 5,000?
Maybe 2,000.
Wow, that's pretty good.
Yeah, they heard you were coming, and so they.
Yeah, all my fans, right?
You can go on the YouTube channel for this. It's under my name and see, but yeah, it's a strange phenomenon. Colorado, California, Kentucky,
Wow.
Denmark.
Denmark. We're even international then, huh?
Yes, I have people that log in from the Faroe Islands and from New Zealand, and I'm gonna go visit the people in New Zealand, I think, in Melbourne.
Right. Well, those folks are like up probably around midnight.
Well, I don't know. I lose track. I know the California people are here 3 hours ahead of time, and the Colorado people. So I don't know much when you go east or west of the United States what the time zone is. But all right, well, let me put you both in a waiting room while I wait for them.
Okay.
Wait a few more minutes and then just bring them back. So thank you for your patience. All right, I'm going to give them a couple more minutes and then bring them back. As I said, we've got the whole hour blocked out, but if we can resolve this sooner than that.
I wanted to make sure they weren't back, Judge. They're not.
They are back.
Okay.
And let me bring them back.
I will wait until he's back, but I have a question that might need some looking into.
All right.
Um,
Well, we've been on the record, and let's go back. The Wyards are in the conference room. I guess, all right, we'll leave you right there for now, in case we need to go back to this. We're turning to Centerville Mobile Home Park versus Roger and Ray Wyard. They're here at the courthouse. They've been in a conference room discussing matters with Meg Bauer from Legal Aid. The owner of the park, Christy DeCenzo, is here, as well as John Capitain on behalf of the park. This was filed as a termination of tenancy for the expiration of a lease for this mobile home in the park. Not just cause, just that the lease was up in April. And then we've been arguing about whether you're able to do that or not in a mobile home case. There's no just cause, there's simply the lease is up. Defendants have been paying their escrow payments each month, and they're current, and the court is holding that escrow funds. There were some other ancillary issues about other payments or other costs that might not have been readily apparent. As I indicated, this is not a non-payment of rent case, it's a termination of tenancy case. Ms. Bauer, you indicated you may have a question.
Yes, thank you, Judge. I emailed Attorney Landman after the previous hearing, asking if he could have his clients provide a verification of continued residency, because my clients needed that with the post office in order to continue to get their mail. I never got anything back. I understand Dan's and Attorney Landman's had stuff going on, so I'm not blaming him or putting anything on him on that. But I confirmed with my clients again today that had we not emailed them the notice to appear for today, they would not have gotten it. They did not get anything from the courthouse in their mail about this hearing. And so I'm wondering, I know the staff always sends those out. I don't know if they were returned as undeliverable or not. That's what
I
I'm
don't
wondering.
see them, I don't see them in the file, but I'm glad they're here. I'm glad you provided additional notice, but they aren't the only tenants that have had trouble with the mail. Centerville has a limited delivery, and they also have post office boxes in the courthouse, and they're very busy. Everybody in town's got a post office box. At any rate, well, let's talk about this case, Mr. Captain. I don't think you can do what you're asking to do. There are two statutes that say you can't do a termination of tenancy for the expiration of a lease. You need just cause. So where are we here today?
Well, Your Honor, I think that there's a misunderstanding as to MCL 600.5775, which is the just cause termination statute in Chapter 57A. And its applicability to folks that rent mobile homes at mobile home sites, as opposed to those that, there's some feedback here, as opposed to folks that own mobile homes at those mobile home sites. And I think it's partially due to the fact that Chapter 57A fails to define who a tenant is in a mobile home park or tenancy. But then again, that's why we're here, because Michigan courts long held that it's a duty of the courts to construe the language of the statute. In construing a statute, courts are required to give effect to the legislature's intent. So that legislative intent has to be gleaned from the statutory text if the language is unambiguous. But when a statute's language is ambiguous, and that's when reasonable minds can differ as to its meaning. And I think that you're reasonable, Ms. Bauer's reasonable, and so am I. And I think that we all have differing opinions. So I think that it's ambiguous, and statutes are generally held to be ambiguous when either one word in the statute has an unclear meaning, or when the statute's interaction with another statute has rendered its meaning unclear. And finally, when an application of the statute to the facts has rendered the correct application of the statute uncertain, like we have in this case. So when it's ambiguous, judicial construction is necessary. And in that vein, the Michigan Supreme Court has instructed that while individual words or phrases, and this is important in the case because we have individual words and phrases, while they're important, they should be read in context of the entire legislative scheme. And to that end, court has to consider both the plain meaning of those words and also phrases and placement, purpose. And it has to be read in conjunction with other relevant statutes to ensure that the legislative intent is correctly ascertained. So turning to this case, we look at Chapter 757A as a whole. And I think that that's where the court needs to first start. We're looking at Chapter 57A as a whole, and not just the just cause statute 5775 by itself. And I think when it does that, the legislature's intent becomes clear that Chapter 57A is solely with respect to owners of mobile homes and not those that just merely rent those homes. And here, I'm going to go into some examples. So if we look at, I think 600.5781. So that's right after, that's after the termination has occurred. And that refers to the sale of the mobile home on site. So it says, Section 5781, if a tenancy in a mobile home park is terminated for just cause, the tenant may sell his or her mobile home on site as provided in Sections 21 HA, et cetera, et cetera. So someone who is renting a mobile home, well, that just makes no sense because they can't sell the home that they don't own. Also, if you take a look at the section immediately following that, 5783, and that has to do with the judgment for possession. So with the just cause termination, every judgment of possession resulting from an action to terminate a tenancy shall, and this says shall, and it doesn't say may, it says shall set forth the right of a tenant to sell a mobile home on site, the conditions of the right, and the consequences of the tenant's failure to meet those conditions. That again doesn't make sense if it's only referring to someone who is renting the mobile home instead of those that actually own the mobile home. And I think it's also important, and the Michigan Supreme Court has also stated that a court has to take a look at the entire scheme or laws related to not just that section, but other sections as well. And here we should take a look at the Summary Proceeding Act. We should take a look at the definitions under MCL 500-701, which is the Summary Proceeding Act. And in that case, definitions under premises, it includes structures, fixed or mobile, and also it includes mobile trailer homes. Okay, well, back in those days, they called mobile homes mobile trailer homes, but it includes that. So again, we have a different terminology. But the Summary Proceeding Act is meant to encompass manufactured homes. So, you know, the Michigan Supreme Court says that a court has to harmonize everything to have it provide or give forth the legislative intent, which was meant to encompass. So this is also a very important thing I'd like to point out is that when this law, when Chapter 57A was enacted, the legislative intent is readily discerned by the Senate Fiscal Agency's analysis of the act, and that was completed on October 4th of 1988. And there, the Senate Fiscal Agency explained the rationale for the adoption of the act, and I'd like to put that on the record, and that is that mobile home park tenants long complained that Michigan law treats those who own their mobile home but rent space in a park in the same way it treats other tenants, when, in fact, mobile home tenants is considerably different. Tenants in an apartment building, for example, who receive a 30-day eviction notice, have 30 days to pack their belongings, find another apartment, and relocate. Mobile homeowners, on the other hand, must either move their mobile home to another park or attempt to sell the home in the park they are being evicted from. Although administrative rules governing mobile home parks require that tenants be offered a minimum 1-year lease, the rules do not require leases to be renewed. Also, many tenants apparently do not exercise the right to a year lease. As a result, whether a lease is renewed or not accepted, the park owner can give a 30-day notice without cause. So they were just giving those that own manufactured homes this additional protection, which is that it has to be just cause. They were not giving those that rent the mobile home in a manufactured home park, because those are the same as tenants within apartment buildings. They have 30 days to pack their belongings. They don't have to worry about selling the mobile home, moving the mobile home within 30 days. Which a lot of times, I believe back in those days, sometimes, you know, it affected those with lower incomes, the elderly, because they didn't have the funds or means to readily move their mobile homes from the manufacturing community. And I think, you know, some park owners, realistic park owners would take advantage of that and allow them to leave and take over the mobile home. So, I think that the intent of the act was clearly to protect the financial ownership interest of mobile homeowners. And I think here contrary to the rationale of the act. The defendant wants the court to hold that any tenancy of a mobile home requires just cause. And I think that basically flies in the face of not only the legislative intent, but looking at the statute as a whole and harmonizing it with the entire Summary Proceeding Act. With that, we ask that this court to construe the act consistent with the intent and grant judgment in my client's favor.
That was very impressive. You've done a deep dive, very deep dive into this act.
Judge, I'm prepared to respond to each one of the points my colleague has raised.
I'm ruling in your favor.
Can I make a brief record? Because I suspect this might get appealed.
Yes, I'm expecting it will also. I'll give you a chance to speak.
Thank you.
I've never encountered this issue in 24 years. The court has always treated a lot and trailer as like an apartment. I see other courts have wrestled with this issue, and it really boils down to the definition of what is a tenant. This law was drafted in 1961. The world's a lot different than it was then. I suspect there were very few cases where people rented the trailer and the lot in 1961. I think people owned their own trailer, mobile home, manufactured home. As you know, they're working on updating this legislation. There are all kinds of problems that district judges are wrestling with. The whole issue of non-payment of rent as opposed to just cause terminations and others. There is no clear answer. And I don't believe there's a clear answer to this, although you make a compelling argument, I think, which would be up to a court hearing this on appeal. All right, Mr. Captain has done an eloquent job of stating his position, which requires some serious scrutiny of the entire act and other acts, and he has even looked into the legislative intent. Someone in 1988 is trying to determine what the legislative intent was in 1961. Ms. Bauer, what's the defendant's response?
Thank you, Judge. I'm going to address my colleagues' issues in reverse order of which they were raised. Referencing the 1988 Senate fiscal analysis makes clear that the Senate understands the words mobile home owners. And the statute that the legislature has in place currently does not use the words mobile home owners in the just cause section or in the summary proceeding section relevant to mobile homes. Entering the arena of legislative intent is not proper when the language is clear on its face. But even doing so, it is clear that if the legislative will existed to change the statute, the legislature would have made a distinction of mobile home owners. They've demonstrated that they understand that distinction. Nevertheless, legislative intent is not appropriate in this analysis because the language is clear on its face. Also not appropriate is the need to look through the rest of the statute, but as my colleague has, let's do that. My colleague references MCL 600.5781 and 5783. 5781 says that a tenant may sell their home on site. Well, it certainly doesn't compel tenants who are renting the home to sell the home. That would be illogical, of course, right? And the statute doesn't use binding language. The statute says the tenant may sell the home on site. Not all tenants, etc. But he says, well, hold on a second. MCL 5783 says that a judgment shall set forth the right to sell. But he's got to keep reading, because it also says that the judgment shall set forth the conditions of that right. And certainly one condition of the right to sell the home is ownership of the home. So the use of the word shall to in this sentence to contort the statute into saying that it was only written for tenants who own their mobile home is to read into the statute things that aren't there. My colleague also says that Summary Proceedings Act provides for mobile homes and those tenancies, and I completely agree with him. But he needs to look at MCL 600.5714 subparagraph 3. There, Summary Proceedings Act says a tenant of a mobile home park is not considered to be holding over under the other sections of the statute unless tenancy or lease agreement is terminated for just cause pursuant to Chapter 57A. Here is very clear that the Summary Proceedings Act, the act providing this court with the authority to proceed, contemplates all tenancies of a mobile home park. Now, we don't need to look at the rest of the statute if a statute is clear on its face. I submit that the statute is clear on its face and no further analysis is required. But if further analysis is going to be undertaken, the court cannot insert an interpretation that adds confusion and ambiguity to the effect of the law. So, to that end, as relevant perhaps in this case, essentially two questions or avenues of thought. When or how does one draw a distinction between owner of a mobile home park and a tenant of a home in a mobile home park? Are we talking about the time at which title transfers? Or are we talking about when someone enters a lease with an option to purchase? Title certainly hasn't transferred there, and yet it is a more permanent form of home ownership. This is a different type of tenancy, for sure, but it is a tenancy nonetheless. And so then that leads me to my second question, which is, if Mr. and Mrs. Wired are not tenants in this mobile home park, then what are they? They are tenants in this mobile home park. Therefore, their tenancy cannot be terminated without just cause. Thank you, Your Honor.
All right, thank you.
Can I reply?
Yes.
Because there are certain things that council wants me to look at. Well, first of all, the Senate fiscal analysis has many different words for mobile homeowners. It says mobile homeowners, mobile residents, and then it goes into residence itself. So there's many different ways that the Senate fiscal analysis actually stated who a mobile homeowner is.
Well, let me speak to this. I'm much less impressed with Senate physical analysis than I am with a court opinion or the statute, but I'll let you go ahead and continue.
Right, and with respect to the statute, the interpretation of the statute is to insert that those who are a mobile home renter is meant to encompass section 600-5781, because it says the tenant may sell his or her mobile home. It doesn't say the mobile home owner may sell his or her home. It says the tenant. So if we take that in the context that encompasses both renters and owners, then we take a look at section 5714 of the Summary Proceeding Act, and it says a tenant of a mobile home park. So just taking the word tenant to mean simply both renter and owner in both statute, if you harmonize that, it doesn't make sense at all. Because taking tenant to mean both means that both can sell the home. So now if you take a look at chapter 57A, which encompasses the just cause, it encompasses the in-person conference, the payment of rent and other charges, the sale of the mobile home, the judgment of possession. If you take a look at that in the context in which all of these sections are put together, it really only makes sense. It's not illogical. It actually makes more sense than the opposite, that this was only intended for folks that own a mobile home. That's all I have.
All right, thank you. The level of advocacy here is quite high, and I appreciate competent counsel and eloquent argument with focus on the law. As I indicated, I haven't dealt with this issue in 23 and a half years, but others have. And the statute needs to get fixed. We need some guidance. But as the defendant argues, this is in two places in the statute. The whole Summary Proceedings Act, which is Act 236 of 1961, Section 57, states in the act itself, in 600-5714, paragraph 3, as cited by defendant, a tenant of a mobile home park is not considered to be holding over under subsection 1B or C unless the tenancy or lease agreement is terminated for just cause pursuant to 57A. So the Summary Proceedings Act says you can't terminate a mobile home tenancy except for just cause. And there are different rules regarding what is just cause, 3 lates and a 12-month period and other issues. Then we go specifically to the mobile home portion, which is at 600-5775, which also uses the word tenancy. The tenancy of a mobile home park shall not be terminated unless there's just cause for termination. Both of those are plain language statute. These people are tenants of the Centerville Mobile Home Park. They have a tenancy. They're renting the lot and the trailer, and they are tenants. They're not residents. They're not non-mobile home owners. They're tenants. And in 2 sections in the law, in the Summary Proceedings Act and in the mobile home section of that act, it says you can't do it unless you have just cause. The language is plain. Some other judges have wrestled with this issue, including my colleague, Sarah Smolinski, in Grand Rapids, who came to the same conclusion I did. All right. The motion to terminate tenancy is denied. No just cause is established or even pled. Case is dismissed.
What about the
Yes.
$7,000 they owe me?
All right, Mr. Senzo, I didn't ask you to say anything, but I'm going to release all the escrow funds to the plaintiff. So the court has I think $3,030 in escrow. That's going to go to the park. If you want to terminate their tenancy for just cause, which includes 3 lates in a 12-month period, you can do that. The law is not clear. Other judges, they cited 2 that ruled exactly the same way I did. Mr. Captain makes a very eloquent argument, but the plain language says you can't do it. So Meg, I'm going to ask you to do an order denying the motion to terminate the tenancy, dismissing the case without prejudice, and releasing the escrow funds to the plaintiff. Mr. Senzo, the rent that the defendants have paid to the court for the last 3 months, I think maybe it's only 2. Maybe it's, I thought it was June, July, and August. I mean, June and July. So I might only have 2. They pay, this was June, they paid June and July. So I have $2,200, which will be released to the plaintiff. If you wish to restart this as another type of case, nothing prohibits you from doing that. But this case, for expiration of the lease, is dismissed. All right, thank you. We'll be in recess.
Your Honor, may I review the order before it's submitted to?
Yes.
I was just going to ask for your email address so that we would attempt to submit a stipulated order. Obviously, if we can't stipulate, I'll submit it under the 7-day.
Right, yeah, I'm not difficult. I'll approve it as to form if it has everything Your Honor says.
One of the problems, Mr. Senzo, is these cases they rarely get appealed. I've been cited a couple of cases, one from a district court, one from a circuit court, but they don't get appealed to the Court of Appeals or the Supreme Court. So we don't have a decision from an appellate court that gives us the answer to this question. And other judges around the state are asking the same question. I've ruled that the language of the statute was clear on its face, and you can't do this. Other people may disagree. Also, the legislature is doing a major overhaul of the mobile home law, which has been needed for 50 years or more. That may give some guidance to judges on this issue in the future. But right now, that's my view on things. All right, Ms. Bauer will send the order to Mr. Captain, and I'll sign it when you both approve it. Thank you.
All right, thank you, Your Honor.
Mrs. Wired, you're free to go.
Okay, thank you.
And have a good weekend.
All right, thank you.
Thank you, Judge.
All right, that was an interesting case that was well argued by the attorneys, but I think the meaning of the statute is clear on its face. They have other ways to do it. They just can't do it that way. All right, that finishes our day.
And that finishes our day. And that finishes at least one case with the Centerville Mobile Home Park. That's the writing on the wall. If I've ever seen writing on the wall. Oh my goodness. I don't have my chat there. That's not the right thing. There we go. I want to say thank you to a whole bunch of people. And I want to read some of these super chats out because, you know, y'all give the super chats. It's cool and everything. Vegas Starlight gives some pause for the cause, some actual pause. Ladies and gentlemen, they were actual pause on the screen. They were amazing. That was an amazing super chat. Thank you for that. Not for a GoFundMe for this guy. I don't even remember which case that was. That was Steven. Thank you for that, Steven. But Coach Social Spam, I don't even know how to say that name, but thank you for the super chat. Spec, I think I completely missed your super chat because I was distracted by you-know-who over here, the little furry friend. This channel should redeem what I didn't have to spend on an airport bottle of water because yous all give me so much. It's embarrassingly mushy, actually. Well, thank you. And look at this. Look at Steven right here. Thank you so much, Steven. I appreciate you. I appreciate you so terribly much. And Charlene's Hut, just saying thank you. Well, I say thank you. And Vegas Starlight wants everybody to remember, pause for the cause, because same Wolf time, same Wolf channel. That does apply tomorrow. We will have a premiere tomorrow night, and we will be doing a brunch tomorrow, weekend live review. We're going to watch some of the stuff that I have on the cutting room floor that I haven't been able to play yet. And I want to start this little credits thing rolling because that's cool too. Thank you all so very much. I've got a lot for us to watch tomorrow. I'm not sure how much we're going to be able to get through. There's at least 2 really long cases that could possibly make up the entirety of tomorrow's live show. But that is yet to be seen. Oh my dear goodness. Straw Carpenter, $5. Thank you for the show and thank you for the super chat. I do appreciate you. I appreciate you so very much. Is it Webster and Revere? I don't remember. I believe it is, Prosecutor Gillette. Not Revere. Look at that. We had an amazing super chat right there. That's so very cool. We'll be able to check all that out tomorrow. Here, let me look in the little unused folder over here because I definitely have a 20-minute Simmons thing that I wanted to watch with you guys that might be a little revenge porn related or something like that. Look at that, the screen went black. That means I need to say bye. But we have a lot more. I got Steven's motion to revoke probation. We're probably going to watch that for the premiere. Yeah. Webster, distribution prelim, Mefford. That's the title. Part of it. It's long. And it's interesting. For now, I am out. See you later. And remember, only you can take a bite out of crime. Bye.